Okay, so one of the subjects that I'm studying that I'm hoping is going to help me become a better voter is Australian law, just the basics of it. And last week I finished the 2 hour contract law video from Anthony Marinac. And now we're going to see if I remember any of it. The problem is, is I actually want to remember stuff that I've studied. Unlike many other things that I've studied, I, actually want to remember it, like the key points, and I don't want to just regurgitate it for an exam and then forget it, right? So the first challenge is figuring out how much I want to remember, like what are the important parts to remember, and then obviously how to remember it. On the first point, I'm not really sure. I'm just going to aim to remember all my notes from the video, and we'll see how we go. See how we go in the future, because we'll get many notes as we go. And I have an idea of using ChatGPT to help me remember things by coming up with questions. And crucially, I'm not going to rely on ChatGPT to verify my answers. I'm going to just rely on it to come up with interesting questions based off of my notes. And basically, if I don't know the answer, then I'll check my notes rather than, say, relying on ChatGPT to tell me if I'm right or wrong. So what I'm going to do, I'm going to show you how I'm going to review my notes, and really I'd like any sort of ideas or feedback or different ways you can think of remembering things, and yeah, and I'll try them out in the future, because I'm going to have a lot of notes for many different topics. So what I'm going to first do is skim read my notes and then put it into ChatGPT and see if we can get it to generate me some questions and go from there. Yeah. So what is a contract? Promise theory. Not all promises are enforceable. Contract formation, we need a capacity to enter a contract. Minors, diminished mental capacity, intoxication. What happens? So you can get the choice to repudiate or ratify the contract. You need the intention to create legal relations. Offer and acceptance. And valid consideration needs to be consideration. And certainty and completeness needs to be clear enough. The contract needs to be clear enough. Construing contracts, express terms, incorporating express terms, implied terms. Express terms, every sentence, paragraph of the written contract are terms, express terms. Okay, right, and implied terms are unwritten terms. And conditions are the important thing. Warranties are nice to have, but not going to completely void the contract if they aren't met. And intermediate can be either. Incorporating express terms, so signature, notice, exclusion clauses, four corners. Unwritten terms. Really, what we learn here is that to be safe, just say, just include this. Only what is written in the contract will be binding, and not prior verbal negotiations. That'll just make life easy. If you have a lot of verbal negotiations beforehand. Force majeure. As you can see here, there's a lot of specific definitions to remember. Choice of law clause. All right, jurisdiction. Tutoring. Implied terms not written in contract or spoken about. consistent course of dealing, industry standards, business efficacy, law generally, ACL. Okay. Vitiating factors, something's gone wrong. We've got mistake, misrepresentation, estoppel, unconscionable dealing, undue influence and duress, and illegality. I forget what estoppel is. Unilateral, only one party has made a mistake. Common. Both, alright, both make the same mistake. Mutual mistake. Different mistakes. Parties make different mistakes. Misrepresentation. Innocent, fraudulent, negligent. Estoppel. Comes out of equity law. If you make a statement to someone about a state of affairs, including a future state, and intend them to rely on that statement, or you know they're going to, and the statement turns out not to be true, and they do rely on the statement, and some harm comes as a result, then you're responsible for the harm even if you don't have a contract. Ah. Okay. That makes sense, except... Even if you don't have a contract, this would still be... That's... Need to think about that. Conscionable dealing. Rescission. Right, this is seeking... So... seeks to take the parties back as far as possible to the position they were in before the contract was formed. So this could be one of the results of one of the I guess results. One of the remedies for something going wrong in the contract. I'm not quite sure what the difference is between rescission and voided. Anyway. Okay, duress, illegality, obvious one. Extra, restraint of trade, prevent the other party from becoming your direct commercial competitor. Okay, so that is some restraints are allowed, some not. Okay, and multiple ways of ending a contract, performance agreements, frustrating or breach. So that's just how it's supposed to have ended. Performances, agreement, contract itself contains a part that describes how it might end, or failure of a condition. Remember, conditions are the important thing, and precedent is something that happened that was required to happen before the contract even commences. And subsequent, and if something happens, then it ends. And just both parties agreeing, frustration, some external event, and a breach, something going, or one of the parties doing something wrong. Okay, and there's a lot into termination by breach. Okay, cool. That was a good skim read. Let's see how much I actually remember. Yes. Okay, so I've got the document, and we're gonna put it. Contract law. Oh, this is all my notes. I'm gonna put it into here. Let's say. Wait for it to upload. Ask 5 tricky open-ended questions based off of the document, and don't give me the answer. I did multiple choice questions before and they were kind of too easy, but maybe multiple choice questions are good when I've just started learning the subject, and then we can move on to something bit more complicated. Let's see. Oh my god. Okay. 17-year-old. Okay, let me make this a bit bigger. Okay. A 17-year-old enters a contract to buy a second-hand car for work, but they already own a reliable vehicle. The seller later sues when the minor refuses to pay. Discuss whether the contract is enforceable and how the outcome might change if the car was essential for the minor's employment. Hold on. 17-year-old enters a contract to buy a second, but they already own a reliable vehicle. So there's two things I'm immediately thinking of. Is one, minors, you can't. There are some. Where is it? Where it's you can't. But surely you can enter into a contract with a 17. This is confusing because like, if you couldn't enter into a contract with a 17-year-old, then. So see here, contract formation, capacity to enter a contract. Everyone is initially assumed to have the capacity to enter a contract, with the exception of minors. Can be enforced by the child, not against the child. Right. Okay. So the seller, who's not a minor, sues when the minor refuses to pay. So it can't be enforced against the minor. So they can't do this. But that seems a little bit crazy, right? Because then who would enter into any contract with a 17-year-old? I guess. Okay, anyway, if we're just looking at my notes, then it can't be enforced. Then the seller can't sue, right? Can I get rid of this arrow? The seller can't sue. Well, they can sue, but the court's not going to uphold it. The court's not going to enforce the contract against the minor, right? And because they already own a reliable vehicle, if the seller, well, there's no issue of damages for the 17-year-old, because I guess they got the vehicle. Because if the seller is suing when the minor refuses to pay, I'm assuming that means the 17-year-old has gotten the vehicle and is refusing to pay, or maybe not. Maybe the seller is suing because they were relying on the minor to pay, and I guess the question doesn't say that the car has actually changed hands. So, okay, assuming the car hasn't changed hands, then if the car was essential for the minor's employment and the seller doesn't give him the car, even if the minor refuses to pay, then there might be damages because the 17-year-old was going to be able to use it for work, right? That seems strange, though. Like, that seems very... I don't know, something about this, like, if we're just going off of my notes, it seems like the seller has to give the car to the 17-year-old and then can't sue the and then the 17-year-old doesn't have to pay for it. I'm obviously missing something. I'm obviously confused about something. This is a great question, though. Where is the damages? Damages. Because the contract can be enforced by the minor, right? So that's where damages would come into play for the minor. Mitigation of loss. Financial compensation. I mean, this seems very strange. Right? I'm not sure what I'm missing, but I'm missing something here. But like, if we're just going off my notes, it seems. Oh, maybe. Okay. Maybe in reality, right? Maybe in real life, because I never bought a car when I was before I was 18. I think I bought a car early 20s, something like that. Maybe in reality, the seller is never entering into a contract with a minor, but rather with their parent or with an adult as some sort of guarantor. I'm not sure how that works, right? And so that's why this seems so strange, because the seller wouldn't get themselves into the situation to begin with. But if we're just going off my notes, then the seller has to give over the car because the minor can enforce the contract against the seller, whereas the seller can't enforce the contract against the minor. And the minor doesn't have to pay for it. Seems very strange. But that's all I got. That's my understanding after watching a 2-hour video. And I'm sure I'm confused about something. If you know the answer, let me know in the comments. That's a great question, though. Okay. During and I'm sure we'll get the answer as we I'm sure we'll figure this out as we study more about contract law. But I don't know what it is now. And we'll do let's do the next one. During negotiations, party A says, "I'll probably continue using your services for years if this first deal goes well." Probably is a little bit ambiguous. Party A spends thousands upgrading equipment in reliance on that statement, but no future contracts are made. Okay, I know what section this is going to be referring to. Analyze whether party B could succeed in promissory... I forgot what estoppel is. Distinguish this from mere expression of hopes. Okay, so the key thing is that party B is spending money on reliance of party A's statement. So, but I think the important thing, one of the important things, remember that there was that long list? Okay, I've forgotten the list, but like, before I check my notes, it's important that party A is not intending this, right? Is kind of lying. Okay, we're going to check my notes. Where is estoppel? Okay, hold on. Estoppel. Okay. So you make a statement to someone about a state of affairs, including future state. Okay, So party A made a statement about a state of affairs. Would this count as that? I guess the state of affairs is them continuing to use the services, right? So that's a future state of affairs, okay? And intend them to rely on that statement, or you know they're going to. I mean, that seems pretty fair that party A would intend for them to rely on it. Because why else would you make it, right? This seems like a pretty clear cut. And the statement turns out not to be true. Oh, so that party A doesn't actually have to be lying about this. Okay, that was a mistake that I made. So the statement turns out not to be true. Okay, that's right. And they do rely on that statement. Yes, because party B... Let me open up both at the same time. Because party B spends thousands upgrading equipment. And some harm comes as a result. Well, is the harm... could you argue that party B spending the thousands, so I guess the harm is the opportunity cost of spending the money on the equipment, whereas maybe they could have spent money on more advertising or something, right? Is that a harm? Would that be the harm? If that's a harm, I think that's a harm. Then you are responsible for the harm even if you don't have a contract. Okay, I don't know. I think that the opportunity cost is a difficult one because party B is still benefiting from the upgraded equipment in their dealings with any other parties, right? So it's like, suppose party B was a cafe upgrading their coffee machine, and even if party A doesn't keep coming for coffee because they've got a super nice coffee machine, they're still going to be able to sell coffee to other people. But party B might have thought, well, for all these other parties, not party A, my initial coffee machine was totally fine, and I would have rather spent the money on advertising, nicer chairs, cleaning the windows, putting a new sign out the front, right? Even if they are still benefiting by having a better coffee machine, and the customers are appreciating that. The other parties are appreciating that, right? I'm going to go with yes. I'm going to go with all the conditions are met. And so what happens as a result? Remedy. Court has flexibility in determining the type of remedy. Right. I reckon it. Okay, okay, and so analyze whether party B could succeed in using promissory estoppel. Yeah, I think it is. I think it meets the criteria. And distinguish this from mere expression of hope. Okay, so it's probably here, the word probably is tricky because, if it wasn't included, if party A said, I'll continue using your services for years if this first deal goes well, then it's clear cut not an expression of hope. I don't know how important the word probably is to turn that statement. It does change it a little bit, but I think what we'd have to do is like to find out the answer, we'd actually have to like read some cases and look at how look at how they've argued for the difference. Look at what the actual arguments are when a statement is being is contested for being an expression of hope versus encouraging / inducing. I'm gonna go with I'm gonna 60-40 inducing. I mean, but like strictly by the words said, probably the word probably does save party A, but I don't know. That's a tricky one. All right, I think this is. I don't want to go too much longer for a video, but yeah, these two questions were really, really interesting. This is kind of gonna be my approach to trying to remember my notes. This may be combined with multiple choice questions, something else. Let me know if you have any ideas, or if you think like, if there are any problems with this, or if you have any other ideas. Like, it would be really cool, say for contract law, if I could find some contracts that are incomplete in some ways, or have some errors in some ways, and I could practice identifying what those errors are. But yeah, that is the plan. I'll hopefully do a review of my notes depending on how bad my memory is, but every week or so, I'll hopefully review all of my notes and see how we go. But yeah, leave in the comments if you have any, if you disagree with anything on my answers to these two questions, and if you have any other ideas on how I can actually try to remember what I'm studying rather than just have it leak out of my brain in the coming weeks. All right, thanks for watching.